Welcome everyone. Hello. Welcome to this interview series promoted by the LLC Labor Law Community, which is an association of labor lawyers based in Italy and open to foreign colleagues. My name is Luca Ratti. I'm from the University of Luxembourg. The aim of this series is to investigate the context, the meaning and significance of some manifesto promoted by labor lawyers across Europe and even beyond. Today, we have the pleasure to have with us Dr. Ewan Gaughey from King's College, London. Ewan is one of the proponents of the British Manifesto for Labour Law and contributed substantially to develop a number of ideas and concepts that we can find therein. The British Labour Law Manifesto has been edited by Keith Ewing, John Handy and Caroline Jones under the umbrella of the Institute of Employment Rights. So first of all, thanks Ewan and welcome.
Thank you.
Today, we talk about the 2016 Manifesto for Labour Law. The first question that I would like to pose you is about the original purpose of this manifesto, and particularly, I'm interested to understand at which conditions was it supposed to contribute to change British labour law at that time?
Yeah, that's a very good question. So if you remember back at the start of 2016, this was before the Brexit poll, but we had already had 2 election victories by the Conservative Party. And so that was in 2010 and 2015, where David Cameron came back with a majority without the Liberal Democrat coalition. But this meant years of austerity, as they called it. Austerity mainly for the poor, that is. The people who are wealthy were doing fine. And that had led to the longest decline in wages in Britain since the Industrial Revolution. So the effect on people's living standard of the combination of conservative policies, attacks on the minimum wage, attacks on collective bargaining, attacks on unfair dismissal, attacks on the whole system of labor rights, perhaps most comprehensively through gutting the tribunal system. There was a drop of 80% of tribunals. All of this had meant that there was a real need to look at labor law afresh. And from the perspective of the Institute of Employment Rights, what previous labor administrations or labor candidates had been proposing was not doing really much more than tinkering around the edges with the policies that Thatcher and Major had put in place. So, still in the UK today, our 2 main pieces of legislation are the 1996 Employment Rights Act and the 1992 Trade Union Labour Relations Act. And so these 2 building blocks are Thatcherite legislation. And some important amendments, some important changes had been made through the Blair and Brown years. Some important proposals were made by Miliband when he ran for election. But the Manifesto for Labour Law was looking at, what can we do if we rewrote labour rights afresh? And how can we get a fair system of work in the United Kingdom? And of course, in the immediate aftermath of the release of the manifesto, or not long after, there was the even more disastrous referendum on European Union membership. And for a number of reasons, as we all know, things moved from bad to worse.
Yeah. And you already mentioned a number of issues that the manifesto touches upon. But the crucial message, if I'm not mistaken, is really about re-getting the system of collective bargaining to the core of any labor law reform. What is now the current situation of collective bargaining system in Britain and how the manifesto aims to enhance its role.
Yeah. So like many European countries, or perhaps most European countries apart from those with the sort of Ghent system of trade union membership, mainly in Northern Europe, trade union membership and also collective bargaining coverage in the UK has been declining a lot. So we are something like a quarter, we have something like a quarter of the UK workforce in trade unions. And that's actually high compared to other countries. But we don't have mechanisms anymore for extension of collective agreements. So, you know, one of the key planks of the Manifesto for Labour Law is that we needed to restore, and still is, we need to restore a system of sectoral collective bargaining, not just enterprise bargaining. So you might know that, and for everybody who's listening might know the sort of background. In the New Deal in America, the original plan of the Roosevelt government under the 1933 National Industrial Recovery Act was to have sectoral collective agreement and sector-wide collective bargaining. That was struck down by the Supreme Court, and you had a resurrection of enterprise bargaining in the 1935 National Labour Relations Act, or the Wagner Act. And in the UK, there was a similar shift in the late 60s. You know, so in 1968, I think, we had the Donovan Report, and that said, you know, at the time, America looking great. It seemed like, you know, the more dynamic economy in the States in the late 60s was something that the UK should emulate by shifting from large joint industrial councils with wage fixing machinery or fair wage machinery across industries. And it said that we should shift to, you know, more mobile and flexible enterprise bargaining. And so really from then, I mean, there's a number of points, but, you know, even before Thatcher, there was already this gradual breakdown in the industrial relations system. And we can see today that very simply, if we look at which countries in Europe or which countries in the Commonwealth have strong collective agreement coverage, it's all systems with sectoral collective bargaining machinery. And I think Germany is an important example because it's somewhere in between. You know, so what German governments in the last 10 or 20 years have been doing is that they've been saying that enterprise agreements can undercut the floor of sectoral agreements. And so, you know, very predictably, that you see German coverage moving from, you know, the sort of higher levels of coverage that we get in Northern Europe downwards in the direction of Britain. So, you know, what I hope is that the Manifesto for Labour Law, although, you know, it starts with the UK, this speaks to the problems that we have everywhere in the Western world, and I think is an important part of how we are going to revive social democracy. Yeah, definitely.
Next point is about another topic that you already mentioned, and because you mentioned a drop in the number of claims that employees, mostly employees, presented before the labor tribunals. And this is very, I mean, this is a typical feature of all systems of labor law where enforcement of labor rights is becoming more and more problematic across many jurisdictions. The question is, what is the proposal of the manifesto about enforcement of labor rights, and more specifically, what are the labor reforms that are needed for employment tribunals?
Yeah, it's a really important question. So what I referred to before is there was, from 2013, an attempt by the Conservative Liberal Democrat coalition to effectively strangle labor rights enforcement in the tribunals. And the way that that was done was to say something like £1,200 fees was necessary if you wanted to bring any kind of employment rights claim. And so there were exceptions, but so for people who couldn't afford it, there were exceptions, but there was a drop of something like 80% in the employment tribunal claims in the UK, which is, I mean, it's not so much, it's obviously bad for the legal profession, but that effectively means that one of the big pillars of labour rights enforcement was taken away. Now, the Supreme Court struck that down in a important case called Unison and the Lord Chancellor. However, it's very clear that, you know, even apart from the naked attempt to destroy tribunal enforcement, there are very big problems with enforcement in UK labour law anyway. So, you know, one of the things that the manifesto proposed, you know, just focusing on the judiciary, is to have a separate system of labour courts.
Yeah.
We all know that when you go to an employment tribunal, there's a judge and two lay people, one employee side, supposedly, one employer side. And, you know, roughly this was meant to be a sort of, you know, like the ILO, a tripartite model. You have the judge sort of representing somebody independent, and then employer and employee. But, you know, the truth is that a lot of employment tribunal judges are not particularly sympathetic to labour, and I know that through personal experience. There's not a big enough body of judicially trained labour rights experts. And a lot of people come from the profession where they are solely or mostly defending employers' interests. So, you know, the idea of setting up a labour court was very important to ensure that people who have the expertise are actually deciding labour rights cases. The other thing, I mean, you know, employment tribunals are mainly responsible for individual labour rights. For collective labour rights, like, you know, if there's a dispute over a strike, those cases are referred to the High Court, which is full with commercial judges and administrative law judges who are downright hostile to anything to do, certainly with the labour, often to do with the labour movement, often to do with strikes. Obviously, I am generalizing, but you can think of countless examples of strike ballots which have 80 or 90% support being halted through an injunction simply on the technicality of the employer not being informed over the ballot in the most notorious cases. Now, there's a few more things. I mean, obviously, enforcement of labour rights doesn't only happen through court. You want to enforce it in the workplace. So sectoral collective bargaining is super important for that, because the union should be, you know, the first port of call for labour rights enforcement. But the other thing, and this is particularly to do with my work, was to restore or build a system of democracy at work, so that we propose that every worker should be considered by default a member of the company that they work for, and by default have a voice. And so what we ended up saying is that at least 2 members of the boards of directors and 20% of the general meeting should be workers. And we said that the Secretary of State should have the right through statutory instrument to raise that threshold above the 2 and 20 model. What this became in the Labour Party manifesto in 2019 was a bit more simplified. It became 200 in companies with over 250 workers, 1/3 on the boards of directors. But we were very, very, although the details weren't spelt out because it's a political campaign, we were very, very adamant that, you know, that the reason for doing this is to make sure that people at work have a sense of ownership and membership in their workplace, and to try and, I mean, one of the key building blocks of democratizing the economy, because, you know, often the problem of enforcement of labour rights stems from the fact that the people in charge are not accountable to the people over whom they exercise power. So that's a really important way that labour rights should be enforced in the future.
Yeah, yeah, thanks. I was about, in fact, to ask you something more about the place of your studies, particularly about industrial democracy, but you already extensively responded to that. You mentioned at last a 2019 manifesto, which, if I'm not mistaken, was titled Rolling Out the Manifesto for Labor Law. Is that another, I mean, is that putting into practice some proposals that were originally contained in the previous manifesto? What is the meaning of this latest development of the manifesto?
Yeah, so there was the 2016 document which set out, you know, the principles for what the manifesto for labour law was meant to be, and then the rolling out the manifesto document was simply how the proposals and the general principles and the narrative from the 2016 document could be put into effect. And of course, the next step is to simply draft legislation. You know the story with the 2019 election and the disaster for Labour and the decimation the second time for the Corbyn leadership, very sadly. And then, of course, there are a lot of complex, well, and so, some very simple reasons about why that happened. You know, I think that the important thing is that we haven't stopped writing or preparing legislation. And I think that we need to do this everywhere. So I personally have been very involved with drafting acts of parliament, drafting European directives. If you look up an economic democracy directive, you will find something I produced for a talk with the ETUI. Working on acts of Congress in the United States, because I think one of the really important things that the labour movement lacks, and what we can do as well as professional labour lawyers and academics, is we can provide options that politicians and political parties can take up. And, you know, if there's material ready to go, then I think that's very important as a way to contribute to the policy debate by showing people what a different kind of system could look like. Concentrate in mind.
Yeah. Coming back to this, I've seen you authored a piece during the Corona crisis in March 2020, trying to revamp some of the ideas that were originally conceived by your 12 points plan for labor law in the current Corona crisis. Is there some of these proposals or ideas that you would like to tell us?
The COVID is so multi-layered. Look, I'd say two things. I mean, the first is that countries which have done better over COVID, economically performing better, are countries with more democratic systems of workplace relations. And there's a number of reasons for that, but the two main things are that if the workforce has a vote for people on the board of directors, then of a company or, you know, the equivalent in another large organization, then it's less likely that those people in power are going to make decisions when faced with an economic collapse or when faced with a crisis that simply externalizes the costs of the crisis onto other people. You know, so it's more likely that if you've got an accountable board in a company or an accountable governing body in a university or board of trustees in a hospital, they're accountable and they're less likely to externalize the costs of a crisis onto the workforce because the workforce will vote them out. And the second thing is that in countries with very strong systems of work councils, particularly ones that have veto rights or delay rights over dismissal decisions, massive redundancies don't happen. So democracy in the workplace and democratic control over job security is probably, so far as I read the statistics, the leading determinant of whether a country is going through a more or less severe economic collapse. Now, what do I mean by that? We're all facing, economic downturn, drop in GDP, no question about it. But the really big thing is unemployment. And if you look at America, they have, both in the global financial crisis and today, a spike in unemployment that is far beyond anything else in the democratic world. And not as bad as America, but pretty bad is the UK, both in the global financial crisis and now with COVID, a huge spike in unemployment. Some of that has been suppressed or delayed because of what we call the furlough scheme, which is basically job subsidies for the employer, not directly to employees. But countries that have had the lowest spikes in unemployment, places like Denmark, places like Germany, still bad, but much lower, are those with the strongest systems of job security. So I think one of the big things that COVID teaches us, and just like the financial crisis and an accumulation of data and evidence, is that democracy and job security is really the best route to get a prosperous economy. I mean, there's many other reasons for justice and fairness, but also because of economic performance, we need a more democratic workplace system.
Very last question, building on this last remark you did. How far can we go thinking of the UK now that is officially outside the EU? So how can we, could you think of a new industrial democracy in the UK without the blueprint coming from the European Union?
Yeah. In many ways, things have changed, appear to have changed a lot because of Brexit. The biggest impact that I see is that as a British citizen, I have lost my voting rights in the European Parliament. I've lost a series of labour rights. And I mean, economically, it's not going to be good. Substantively, Brexit is number one, a geopolitical disaster, not just beyond, it's bigger than economics and questions of identity. It's a geopolitical disaster. But substantively, an awful lot is the same. So, all of EU law is still UK law. Most of it has not been changed, and there are no foreseeable plans, at least by the Johnson government, to start tearing up a lot of labour rights. And by the same token, in the EU, we have had 40 years of the UK's being involved with and shaping EU legislation. And every time I go back to look at company law, to look at the takeover directive, to look at just so many different areas of policy, the four freedoms, this is all, for better or worse, shaped by the UK's membership of the EU. And fundamentally, I don't think that changes. We are now more disconnected in the same way that Norway has been, in the same way that Switzerland has been. But substantively, I don't think that very much changes. And more importantly, and this is the answer to your question, more importantly, ideas don't stop flowing across borders. You can build a wall. You can have a big channel separating the continent from the islands. It doesn't stop. It might stop people. It might even stop the flow of capital. And law can erect more barriers, but it's very hard to erect borders and barriers and walls against the flow of ideas. And I've always thought as a European citizen that one of the problems with the European Union, I mean, from my time in university, is that there used to be this narrative of the United States of Europe, and particularly around the Iraq War, that the European Union needed to become a new superpower. and to rival the United States then under George W. Bush. And that was also linked to this narrative of fortress Europe. And we saw this in the migration crisis, and we see the same kind of nationalist tendencies arising within Europe and the rise of the far right in Poland and Hungary, to turn the European Union into exactly the opposite of what it was meant to be, to make it a big, strong nation state instead of a project which supersedes the nation state. So I say all this because when we're talking about the future of labor law, we have to think outside our own borders and outside the European Union, because as European citizens or as a UK citizen, we have exactly the same problems as in Australia, Canada, Japan, Norway, Switzerland. And we have the same fundamental building blocks. And it's about ideas, which have led to the disaster of the electoral situation that we now face. So, I mean, and because we've all been watching the American election, in Florida, Biden was trailing by about 1 million votes in Florida, compared to a $15 minimum wage ballot. And so the big problem with the Democrats in America is shared by a lot of social democratic and progressive or socialist parties around Europe, which is that we've lost a conviction and very simple answers about how we improve people's lives. So, I mean, I hope that that Brexit doesn't do too damage, probably will, but fundamentally, I think that the conversation that the UK has is still about our system is still the same thing as the European conversation, and still the same thing as an international conversation.
Yeah, it should probably be so. Okay, good. Thanks very much, Ewan, for this talk. And I'm sure all the people watching to the labor law community will very much appreciate your take on this. Thanks very much.
Yep, and thanks for talking. Good to see you.